right, good morning. I'm Judge Haan. This would generally be Judge Evans' docket, but we had to have a switch of what we were doing -4. I see that we have Ms. McLean online. And sir, is that how you say your name?
Bondurant, Your Honor.
Okay, I'll probably misstate it again. I apologize.
It's okay. It's okay.
All right.
We were before Judge Basher, I think it was last week or the week before. He, if I recall correctly, entered the order on adequate cause. He entered a modified temporary order and a restraining order. And he set this over for the determination of a parenting plan, default, and referral to guardian ad litem. In the interim, Mr. Bondurant has filed a response to the petition, so we would withdraw the request for the default. However, I would ask that the court take that into consideration as it relates to my client's request for attorney's fees. And then as it relates to the actual parenting plan and guardian ad litem provisions, we are obviously, the court's had an opportunity to review, at least through the history of this case. This case started with a protection order, which is still in place. That was entered on September 12th of 2023, and that protects Ellie, who's 14 years old, from her father at this juncture. Ellie, unfortunately, has been exposed to domestic violence within her father's household, and Ellie has obviously at an impressionable age. Our position is that Mr. Bondurant should be modeling appropriate role type or an appropriate parental role to his child. Instead, he has engaged in domestic violence, substance abuse, which is primarily alcohol, untreated mental health, and instability in all aspects of his life. If you go back and look at the findings from the protection order, and that was a contested protection order hearing, at that time, Commissioner Carmi found that Mr. Bondurant is a perpetrator of violence within his household, and that Ellie experienced anxiety, apprehension, worry, and that she engaged in preparing a safety plan with her own mental health provider because of the exposure by her father. During the most recent domestic violence incident, Ellie was directly involved. And during that incident, Mr. Bondurant interfered with what he perceived to be Ellie's reporting of the domestic violence to 911. The domestic violence was occurring. Her stepmother, Chelsea, had hollered down the hall for her to call 911. Ellie was so scared of what potentially her father would do that, in fact, she texted her mother, Ms. Peterson. When Mr. Bondurant saw that she was on her phone, he grabbed it and threw it, which, at least in his mind, is interfering with the reporting of a 911 call. And then when he found out that she had texted her mother, he demanded that she text her back that everything was fine. Shortly thereafter, Ellie's stepmother was able to remove Ellie and herself, and I believe the other children, and she took Ellie to her mother's home, where Ellie was distraught. She was crying so heavily that she was hyperventilating and having difficulty forming words. She was immediately comforted by her stepfather while her mother was trying to get information from Chelsea, the stepmother, to figure out what had occurred. Ellie has disclosed to her counselor about the struggles with her father's behavior. She's described their relationship as negative, poor, and non-existent. And Ellie's relationship, quite frankly, appears to be more strongly bonded with her stepmother and her half-siblings. Since Ms. Bondurant's, Chelsea Bondurant's initial protection order, which was entered earlier this year, Ellie was exercising her father's visitation with the stepmother and the siblings rather than with Mr. Bondurant. Mr. Bondurant did not exercise his summer visitation this summer. And it is concerning about Ellie's, again, information that she provides to her counselor, which we provided in the counselor notes. Mr. Bondurant claims that he was not advised when Ellie was first engaged in counseling. We provided in my client's reply documentation the text message that shows back in 2020 their communications about my client's concerns and engaging Ellie in counseling. And then, of course, obviously, we weathered the COVID pandemic for the last several years. And obviously, when you have a child, particularly a teenager, who's saying that they need some emotional support, in this day and age, you can't take that with a grain of salt and you need to take action. And that's exactly what my client did with full notice to Mr. Bondurant. Mr. Bondurant, despite being advised by my client about the difficulties that Ellie has expressed with him, has not participated in any type of counseling with Ellie to try and rectify those issues. And Ellie is saying at this point, she does not want to have a relationship with her father. She's afraid of him. He's put her in too many difficult situations. One of the other situations that's prominent is Mr. Bondurant being intoxicated and demanding to be able to drive Ellie and her older sister while he was intoxicated, and Ms. Bondurant Chelsea having to step in so that these children were safe. Mr. Bondurant has a long-term mental health history that is not currently being treated. He does have a prior attempt in 2018, which resulted in an ITA to St. John's Hospital. And shortly after that, there's been no indication that he has continued with his own mental health counseling, his own medication management, and the like. What we are asking is that the court enter a parenting plan that provides for continuation of no contact. If you look at the documentation that has already been entered in the active dissolution case with his current wife, Chelsea, the temporary parenting plan entered in that matter has already entered 191 findings against Mr. Bondurant for domestic violence, assault, and emotional or physical problems. We're asking for those same findings, as well as a finding relative to substance abuse. It's our position that Mr. Bondurant should be evaluated for those concerns, and that those evaluations should include a psychological evaluation with parental risk components, a domestic violence evaluation, and substance abuse evaluation. And those should all be collateralized evaluations with input from my client and input from the guardian ad litem, assuming the court appoints one, as well as input from Chelsea Bondurant, who has been his spouse for the last several years. He should also be required to start any recommended treatment, and evaluations, treatment plans, and the like should be provided to the court under seal and all parties, and those should be at Mr. Bondurant's expense. As it relates to the last time that we were here, actually, I guess it was 2 times before, Judge Evans had indicated that Mr. Bondurant was required to provide notice of who his counselor was that he was going to be doing an evaluation. He had made a representation about an evaluation. There has been an order in the divorce case with Chelsea that he had to go a mental health evaluation. And he had disclosed to us Mr. DeLagrange at Store Health. He provided that information timely. My client has provided some input to Mr. DeLagrange. I don't know Mr. DeLagrange's qualifications. I don't know if he's doing a psychological evaluation or if he's simply doing a mental health evaluation. But given the long-term history, we think it's appropriate for there to be a psychological evaluation. We also have not received any follow-up evaluation or results from Mr. DeLagrange. So we're asking that the court enter the 191 factors that have been proposed both in paragraphs 3A and 3B of our proposed plan. We're asking that the court also take into consideration that, again, my client's request for attorney's fees. We are asking for a contribution of $2,500. We did file the default motion because he had not filed a response to the petition within 20 days. I would also note that he's here with unclean hands in that he's currently about $10,000 in child support arrears. He also has an outstanding judgment against him in this court for an outstanding attorney fee award owed to my client for $1,500, which was entered back on October 21 of 2020 when his adequate cause motion at that time was denied by the court on initial motion. If you go back and look at the attachments that I provided from his divorce case, his financial source document indicated that earlier this year, he had grossed $15,840 between January of 2023 and April of 2023. That provides him with a gross of $5,280 per month. Her net is about $4,300 per month. Obviously, she's taking on 100% of Ellie's care. And we're here because of Mr. Bondurant's behavior. So we do believe that it is appropriate to award my client $2,500 in temporary attorney's fees. Assuming that you do decide to enter a guardian ad litem order, I have provided that to you. We would need to make some changes to the proposed date since our hearings have been set out, and that would be on page 3, and I can walk you through those at the time of your ruling if you decide to appoint a guardian ad litem.
So, Mr. Bondurant, I'll hear from you in just a minute. I wanted to first take care of the order regarding the default, so it's taken care of and not missed.
Okay.
Bottom line is I've stricken some parts out of it with the final order being the motion for default is denied. The other party basically, bottom line, has responded, so not in default. So, Mr. Bondurant, any objections to my signing off on that order?
No, Your Honor.
Your Honor, would you also make that change on page 1 up in the heading where it says granted? And just change that to denied.
Oh, okay. Okay, so what I've done on paragraph 2, I have stricken the word not, and in paragraph 9, I have stricken the word granted and put denied, and then entered the other party, Levi Bondurant, is not in default, and then have stricken that next
Perfect.
line.
Thank you.
All right, so that one is done. All right, sir, go ahead. And what would you like to tell me?
First of all, Your Honor, like I said, I've made it to every single court date thus far. I filed every piece of documentation that's required by the courts. Maybe, like I said, I'm not an attorney, so I'm doing my best to try to put things in a timely fashion and and as professional as a manner as possible. I've supplied the courts with a declaration that I'd hope that they would use as a source of information in regards to the situation. Mrs. McLean mentions a history of domestic violence. My question to the courts would be where is this factual information at as to a long history of domestic violence? There is none, Your Honor. It's all hearsay. In terms of substance abuse, Your Honor, there is absolutely nothing in the courts to show any sort of instance of substance abuse. Matter of fact, the judge, a previous judge ordered a hair follicle test. It was not done the same day. The judge ordered it the next day. I did get it the next day because that's when the funds would be available and when I would be in town. And I took that test, passed the test, and I have no history of DUIs. I have no history of a failed drug test in any courts. Matter of fact, through the Department of Corrections that I spent 3 years on, I never failed a UA, not one time, or was violated. So there is no history of substance abuse, and that includes alcohol. That was on the panel that was provided to the courts. There is a allegation of domestic violence, and I take that very seriously. I am doing everything that I need to do in terms of the legal side of it, the criminal side. I don't want to speak too much on it, Your Honor, because there is still a criminal case in regards to that.
So I want to make sure you understand your right to remain silent and not talk about if with the pending criminal case. All right. You
Absolutely.
understand that?
Yeah.
Okay.
Yes, Your Honor.
All right.
So like I said, I don't want to touch too much on it. What I will say is that the information that Noelle McLean has is not reflective to many different statements and police reports. As we were to go along a little bit further, I think if a guardian ad litem would be appointed, the guardian ad litem would be able to look at some of this documentation and would be able to see that there is a lack of information and that Ms. McLean is either Noelle McLean or Tristan Peterson is fabricating information to make this look much more dramatic than it really is. I do again take it very seriously, and I've been here every single day that I needed to be. I'm just now starting work again. I've been unemployed for almost 6 months, so the financial declaration paperwork is not reflective to what's going on. Like I said, I actually start work here in 20 minutes. And I'm sitting in the parking lot as we speak. I've undergone the mental health psychological evaluation that was required in another court. A guardian ad litem was appointed in that court also. So I would ask that a guardian ad litem be appointed.
Is that in this jurisdiction? Is it in this court here, your other case?
Yes, Your Honor.
Okay, who's the guardian ad litem in that matter? Who's in that case?
Amy Turnbull, Your Honor.
Okay.
Your Honor, I supplied a parenting plan. I've done everything in the best case for Ellie as things are presented to me. I'm not perfect. I'm not trying to pretend that I am. I've made a series of mistakes in my life, and I've done things to rectify them. I've shown the court that I'm willing to continue to keep fighting and keep bettering myself. I presented Ms. McLean with a parenting plan that literally provided me with no visitation. I did that because I felt like it was if it was in the best interest of Ellie, then the literature in that presentation of that particular parenting plan is that any visitation with me would be completely at her discretion, and that was not good enough. So I don't know what else Mrs. McLean wants. I've jumped through all the hoops. She wants me to go through a mental health evaluation, psychological evaluation. She wants me to do substance abuse stuff that I'm not literature. I don't even understand most of it. For what? For me to not have any visitation of my child? That's basically what she's asking for. She wants me to jump through endless hoops, and there's nothing in there that suggests that she has any desire to bring my child potentially a relationship or rebuild a relationship back up with my child. So at the end of the day, I don't know what to do. There was an earlier case with Ellie when we originally started the visitation process. I don't recall the year, Your Honor. The guardian ad litem in that report provided me much more time than that I ended up taking. Mrs. Peterson actually told me that it was going to be in the best case of Ellie if we integrated it slowly. So I went to every other weekend, and I've been like that for the last almost 10 years.
Seems to be exceeding the scope of the declarations at this juncture.
All right. So anything else that you want to add? Okay.
No, Your Honor.
Anything in response?
Just that the child has reported more than one incident of being exposed to domestic violence. Chelsea Bondurant's declaration that we provided as an exhibit to my client's initial motion declaration in this matter, as well as my client's husband, Ryan Poss declaration, all speak to Ellie's behavior, being distraught about her father's behavior and what she's been exposed to. Chelsea Bondurant discusses multiple instances of domestic violence that Ellie has observed and been exposed to, as well as Mr. Bondurant's alcohol consumption concerns. So we stand by our request.
Your Honor, if I may say something.
We're done. Okay. All right. So here's what I'm going to do. First off, I am going to appoint a guardian ad litem. And my thought is to have the same guardian ad litem. It seems like it would be, having two different ones, I'm not sure makes sense. So that's what I would propose. Any objections to that?
No,
I don't have any strong objections to that. I don't know about my client, but I understand the court's position.
Okay, so I am going to appoint Amy Turnbull.
Turnbull.
How do you? Oh, Turnbull.
Turnbull.
And
then at the top of page 3, the 120 days that's identified as February 29, 24 needs to be changed to April 5th of 24.
Where are you looking?
Line 2.
Page 3.
Page 3. So change the 2/29/24 to 4/5/24. And we are asking, so I will tell you that I wasn't aware of Mr. Bondurant's fees when I originally provided this at county expense. I know that he apparently he claims he's been out of work, that he's now got work. Of course, so I provided at paragraph 10 as far as county pay. Obviously, my client is asking that if you allocate any portion to her, that hers be county pay, given the fact that he is so far behind in child support, and she now has 100% of the responsibility for Ellie.
So at this point, I'm going to do 100% county pay. It sounds like the father has just gone back to work. I don't know what his pay is. It is subject to change later. So if we find out that you're making good income, then that's going to change. But for now, I'm making it county pay.
Okay.
So, sir, are you okay if I put approved via Zoom on this one?
Yes, Your Honor.
All right, and then you'll need to sign off on release of information since I don't have your signature on this order. It does have the child's signature and the mother's signature. So you'll need to get that to the guardian ad litem and make sure to sign so she can get your documents that she needs, okay?
Okay, Your Honor. Thank you.
All right, so that guardian ad litem order is done. So now the parenting plan.
And I'm sorry, I'm sorry, may I take you back to the GAL appointment order?
Sure.
On page 5, I had Mr. Bondurant's old address. He's since moved again.
And then in regard to the parenting plan, I think the easiest thing is to go through this and then let's see. Yeah, go ahead.
I just wanted to remind the court that I actually have to go into this in about 10 minutes. So
I'm
hoping
trying to go through this rather quickly.
Okay.
All right. So in regard to the limitation paragraphs number 3, I'm going to reserve those. Going to paragraph 1. So it's very clear, and Ms. McLean, I know you can always bring a modification, but I put it subject to modification after recommendations of guardian ad litem. So I want the dad to understand that. So this is for now. All right. In regard to the limitations or the 191 factors, at this point, I'm going to reserve. I am going to leave in about the urinalysis and the hair follicle and that for now. On 4A, 2B, both shall be enjoined or restrained from talking negatively. As to the evaluations, again, I'm going to reserve for now because I want input from the guardian ad litem. And when you talk to Ms. Turnbull, I'm looking for her to have some input by that 30th day. So when you have that first review, if she can just have some input as to those evaluations. And
is it possible that you can provide that or write that in on paragraph or page 3 of the GAL appointment?
And I'm hoping because she has some contact via the other case that's where that 30 days will be enough time.
Okay.
All right, and then I'm leaving the decision making as proposed for now. And then reasons for limitations at this time. There is a DV no contact order in place, correct?
There is a protection order.
Protection order.
And a restraining order in this case.
Okay. So I'm reserving what's here. But ordered because of DV protection order.
All right, we will
Okay.
provide Mr. Bondurant with a conformed copy once those are available on Odyssey.
Okay. So for now, it's this. I'm really looking for input from the guardian ad litem. I am ordering the rest of what's here at this time.
And then there was a request for fees. Do you still have a temporary family law order there?
I don't have a family law order. So in regard to the fees at this time, until I have current financial information from the father, so you need to get that provided and filed, okay? I'm reserving on the
Your Honor.
fees pending current documentation of finances. All right, sir, are you okay to put approved via Zoom on the parenting plan at this point?
Yes, Your Honor.
Okay. I believe Fridays at 8:45.
8:45.
Fridays at 8:45.
Okay, what about?
I can't have any.
Okay. All right, so we can do it this Friday or the next Friday.
This Friday's fine.
Okay.
I'll get it.
Your Honor,
emailed.
If you don't.
Your Honor,
Okay,
sorry.
just listen up real quick. If you agree with the order that she proposes, you can sign off on it and then you won't need to appear on Friday at 8:45. But if you
Okay.
don't agree, and it's just what I ruled, nothing more, okay?
Okay, perfect. Awesome.
All right.
Thank you, Your Honor. That's all I needed for clarification.
All right, that's it for today. All
Thank you.
right,
Thank you, Your Honor.
Counsel, go ahead.
Thank you, Your Honor.
Thank you, Your Honor. For the record, Carly Bliss on behalf of the petitioner and moving party, namely Natasha Geese. This matters before the court on my client's motion to request father submit to a hair follicle test and suspend visitation pending a clean hair follicle test. My client outlines her concerns within her motion, looking primarily to the temporary parenting plan entered this time last year. There was 191 findings for substance abuse for father. He was required to undergo an evaluation. Upon receiving the results of that evaluation, it indicated father was not recommended any treatment due to actively being in recovery and not having any recent relapses. My client provides for the court within her declaration some concerning statements, not only made by the mother of Mr. Geis's other child, but the fact that there are current CPS investigations relating primarily to suspected drug use. My client provides for the court that she is very concerned. This is a tender age child. Ezekiel just turned 2 years old and frankly is incapable of protecting himself against any suspected drug use. Within the allegations to CPS are Mr. Geese not only leaving his children alone while he goes to the bar, and mind you, his oldest child is 8 years old, so potentially leaving an 8 and a 2-year-old alone to fend for themselves while he's at the bar. There's some admitted cohabitation and being around drug use. Mr. Geese specifically said he's residing with his mother and there are known methamphetamine and cocaine users within the home actively doing drugs in front of him. Again, this is also concerning, again, given the age of the children who are residing with him, granted on day visits, but unsupervised within his home where there is this active use, admittedly by Mr. Geese. There are some significant concerns. My client's simply asking the court to order Mr. Geese comply with a hair follicle. Again, given the recommendations of the evaluation this time last year, there was no specific language for hair follicle testing or UA testing, which we typically see when we have those 191 findings, especially when it relates to substance abuse. But given the active recovery and no recent relapses where Mr. Geese was this time last year, my client didn't request that language as she was hoping that he was on the up and up. Given the fact that there are these concerns, and I don't believe in Mr. Geese's filings that there was any objection to completing a hair follicle if the court ordered one. So that's our request today. I will note in Mr. Geese's pleadings that he provided for the court, he provided some drug testing. If the court were to look at that drug testing, one of which, the very first one, shows that it was an oral swab. The court knows, and I'm sure the court is aware, with oral swabbing, that only goes back 48 hours. And if you look at the initial results, he tested positive. And then it says later it was concluded that it was negative. So there's some concerns there, not only the length of time that the testing covers, which is 48 hours, but the fact that the initial testing deemed positive. So there's some concerns there. If you look at his, it looks like some UAs that he provided prior to his employment, he tested positive for marijuana. Again, for somebody who has an addiction history, someone who is supposed to be refraining from everything, alcohol, marijuana, illegal substances, even testing positive for marijuana is telling that there has been a relapse of some sort with Mr. Geese. Given the tender age of the child, given the history of substance use and abuse, we are asking that the hair follicle test be ordered, that he immediately comply with that today, and that visitation be suspended pending a clean follicle test.
All right, sir, go ahead. Anything?
So I'm willing to submit any required testing that's asked of me, and using marijuana is not illegal. And I talked to DCS, which DCS did the mouth swab, and I even asked them why it came up positive for what it said positive and then negative, and she said that she doesn't understand why it came up positive and then negative, but they don't look at it that it came up positive at all, and they're closing out the case, the DCS is. And I asked her if they would be able to get me the report so that way I could submit it before the courts today, and she said that she wouldn't have it in time for me to be able to submit it.
All right, so sounds like you're not objecting to do this. Ms. Bliss, what panel are you asking for?
Usually I request the 9 or 10 panel just because it does include all of the potential amphetamines. It does include marijuana, and it's not as costly as the 17 panel. So I think the 9, or I can't recall if it's a 9 or a 10 panel, but that's typically the one that we usually request.
Can you check to see, because I was going to include it in the order. I want to, so that the testing agency knows what it is that they're testing for.
Let me see.
I'm not in any financial disposition to be able to afford that, by the way.
I believe it's a 10 panel, Your Honor, is what I just looked it up, and that's usually what we request.
Okay, so.
And if Your Honor looks at my order, my client would be advancing the fees for that testing. And if it does come up positive, then Mr. Geese would be responsible for reimbursing, but cost should not be a prohibiting factor in this matter.
So I am going to go ahead and order the request. I'm going to include in here 10 panel. I am striking the blood test. I think that's too invasive. I don't think that's appropriate. And it will be up to the mother. Are you also wanting, because if the suspect is it alcohol intoxication? Is that what you're thinking?
That his current use is, I mean, that's one of them. Obviously that coupled with his exposure to methamphetamine and cocaine usage within his home.
I do want to go ahead and have a test done now. Basically get a bottom line. All right, so here's what I'm going to do. I am going to go ahead and order the 10 panel hair follicle test. Well, I'm going to sign the order, but also I've written in the father is to do a hair follicle test by 12/5/23. So today he is not to color or cut his hair until done. And then I want to set this back on. And how quickly do they get those results?
Lately, I've been seeing 3 or 4 days post-test is usually when we get those back.
Okay.
So ideally, we'd have it back before next Tuesday, or if that was what Your Honor was anticipating.
That's what I want to have this order reviewed next Tuesday. So let's do an initial hair follicle test. And the mother will pay for it at this point. That can be argued later. But then I'm going to set a hearing for next Tuesday at 9 o'clock. And that way the results can be seen, because it'll go back 90 days. So you're going to know if he's been using or not. And so I'm going to add a paragraph 4. This order shall be reviewed That would be December 12. To determine if it should remain in place. All right, so again, I made the change of adding or 10 panel hair follicle test under paragraph 2. I did strike the word blood test, and I did add the father is to do a hair follicle test by December 5/23, is not to color or cut his hair until done. And then I added a paragraph 4. This order shall be reviewed December 12/23 at 9 a.m. to determine if it should remain in place. Okay.
Very good.
All right. So are you okay to put approved via Zoom on this order?
So I'm going to take a hair follicle today.
Correct.
Okay.
Okay.
When
so
do I, when do I get
hair?
right?
So
When do I get the,
be in contact with Miss Bliss, and
Okay.
I'm assuming Miss Bliss, you'll give him directions as to where he needs to go.
Correct. I can do
Okay.
that.
so I work in Battleground, Washington. I'm at work right now. Am I going to have to leave work to go do this?
I can
Where-
look for a location near Battleground so he doesn't have to travel all the way up to Kelso Longview.
Okay. So I would just stay in contact with Miss Bliss and get that worked out. Okay.
Okay.
All right.
And Judge, I didn't see on the docket, this was also supposed to be pre-trial. It was on last week on Judge Fassett's docket, but she had recused because she had heard the MSC. I just am concerned if we don't just deal with the procedural issue of pre-trial, and when we get to trial, the court may, strike it for not completing that.
So I did not have it on for that purpose, but let me ask the clerk, any problems with just adding that? No. Okay, let's go ahead and address that. When is your trial date?
I think it's set for the week of the 19th or the 18th.
Let's see, December 18 is when the non-jury trial is set. All right, so, excuse me, you do have a trial December 18. I'm assuming via Zoom, is that correct?
Correct.
So that'll be via Zoom. And sir, you understand that if you go to the Cowlitz County Superior Court website, it talks about having a Zoom trial, and it tells you the process if you have evidence such as documents that you want the judge to see, how it is you go through the process to get those to the judge. Okay. Okay. All right. And that will be your day to present any evidence, whether it's verbal testimony or documents. So make sure to get on there right away and make sure that you timely get everything sent and provided to the judge. Okay. And it's always good to do bench copies just so they have that. And then you need to make sure to also, whatever you send, you need to provide to Miss Bliss. Okay.
Right. Yeah.
Okay. Miss Bliss, anything I missed?
Nope, I have no concerns. Just Mr. Geese, if you can just be sure to provide me any witnesses that may be testifying at trial as well, in addition to yourself.
Do you have any witnesses you think you will be calling?
I don't know what I need a witness to in this situation exactly.
Okay, well, why don't you think about it for a couple days, see if there are any witnesses that you want to have appear and talk about you and what, kind of whatever it is that you want to present to the court. If you don't, that's okay. But if you do have someone, then Ms. Bliss also has a right to their name, address, and phone number. Okay.
Right. And my opinion on the situation is that we're just getting a divorce. It's not a criminal matter or anything along those lines. And I don't necessarily feel like that somebody needs to stand up in my disposition, because that's what we're doing in this case is just nullifying the marriage. And so I just don't understand.
That's up to you. And whether you want to maybe consult with Cowlitz Wahkiakum Legal Aid, just to make sure you're doing everything, because that is your day of trial. And you're right, it's not a criminal trial, but it's still involving you and your life. So you want to make sure that you look at it as important, and which I know you do, but that will be your day to present evidence. Okay.
I understand. Thank you.
Okay. All right. All right.
I have a question. pertaining to the hair follicle, and it's gonna, as it shows negative results, can we nullify any further actions on drug testing me, because this is a consistent and persistent harassment against myself, because this
Okay.
has been ongoing since the beginning of this
Listen to me for a
divorce.
minute. That's why I put it on next Tuesday
Mhm.
to
Okay.
review it, to see whether or not the order is going to continue.
Okay.
Okay, if it comes up negative, then it may be that I'm assuming Judge Evans will be back. He may decide that it doesn't need to stay in place. I don't know. I can't make that decision until everything's done. But that's why I put it on next Tuesday. Okay,
Thank you.
okay, all right,
Thank you, Judge.
all right. That concludes